Hi everyone, you're watching the Virtual Amicus and I'm Jay Lodha. So today's topic for discussion will be on applicability of group of companies, doctrine in an arbitration. So applicability of group of companies doctrine. Now what do we mean by, so in broad and simple terms, if we may define it, it allows a non-signatory to an arbitration agreement to be included as a party to the agreement arbitration. So which means that a party which is not a signatory, it allows that to be included as a party to that arbitration, as this non-signatory may form a part of the same group of companies as one of the signatories to this arbitration agreement. Now the question here is it contrary to the basic principles of separate legal personality? Now it definitely is this doctrine a novel concept in Indian jurisprudence. And but the question here is it explicitly defined anywhere in the provisions of the Indian Arbitration Conciliation Act? Now, what are the recent rulings or judgments of delivered by the Honorable High Courts and Honorable Supreme Court of India as far as interpretation and applicability of this doctrine is concerned? Now, to assist us further and better, we are joined by a very dynamic counsel who joins us from Delhi. We are joined by Mr. Abhishek Shivpuri. And just to give you all a brief introduction about our amicus for today's session, Mr. Abhishek Shivpuri is a principal associate in the litigation dispute resolution arbitration practice of ELP and is based in Delhi. He began his career with LNL Partners, which is erstwhile Luthra & Luthra, New Delhi, and is admitted with the Delhi Bar Council. And he's a member of Chartered Institute of Arbitrators, London, Young International Arbitration Group, which is sponsored association of London Court of International Arbitration, Young ICCA, which is International Council of Commercial Arbitration, and Chairman Legal and Finance Committee, PhD CCI, which is in the Rajasthan chapter. So thank you so much, Mr. Shivpuri. So sorry we spoiled your weekend plans. We had to call you on a Sunday evening, but really nice of you to have kindly consented to be a part of this segment that required that demanded your expertise. So anything that you wish to say before we start with our segment?
Hi Jay, it's a pleasure being here on your channel. Thank you for inviting me. And I've been seeing your videos lately, and I've been seeing that you've been inviting wonderful lawyers on very relevant topics in law. So kudos for that, and may your channel grow even more. So
really
now
nice
coming
to say that. Now coming back to the topic, I think it's over to you.
Sure.
We start with your presentation.
Sure, Jay.
Thank
you. So I chose this topic because I revisited this topic in a recent international commercial arbitration that I was handling. And then also this Amazon versus Future Retail Limited case was also in the limelight for the past few months. And in that also this doctrine was relied upon one of the parties by Amazon, and it was part of the discussion before the Delhi High Court, as which gave a detailed judgment on this, which was then eventually challenged in the Supreme Court. But we'll talk about it later. So let me start with the seminal judgment of Chloro Controls, which actually established the group of companies doctrine in arbitration in India. So Chloro Controls case, the Supreme Court was faced with the issue that there were 7 different agreements between different parties. There was one shareholders agreement, and then there were 6 other different agreements, and then different entities were parties to these agreements. So the arbitration involved was a foreign arbitration. The Supreme Court was dealing with Section 45 application. Section 45 is basically similar to Section 8, which basically when you approach a judicial authority for referring the parties to arbitration, and the judicial authority is bound to refer the parties to arbitration, except in few situations, such as when the dispute is not capable of being settled by arbitration. Then the arbitration agreement is not capable of being is not operative, is void and unenforceable. So in those kind of exceptions, then the court does not refer parties to arbitration, but usually it does. So the Supreme Court was dealing with Section 45 of the Arbitration Act, in which the language which says is that party applying to the court under Section 45 or any person claiming under that party. So the court was construing this term, person claiming under that party, and the court said that it's a very wide term. So that's how the finding of the court begins. On the basis of those terms, then the court refers to certain authorities, because at that time there were no Indian authorities that the court could rely upon. So then the court considered the authorities, established authorities in international arbitration, like Mustel, like Russell on arbitration, Gary Bond, and then it said that there are certain circumstances in which a non-signatory can be referred to arbitration, can be bound by the arbitration agreement. And those, one of those doctrines, group of companies doctrine, in which there are three conditions that have to be satisfied. And what are these three conditions? These three conditions are: first one is direct relationship of the signatory to the non-signatory party. The second condition is commonality of the subject matter, and the third is the agreement should compromise a composite transaction, in as much as they should be intrinsically linked to each other in such a way that the mother agreement cannot be performed without the supplementary ancillary agreements. Now, these are the three conditions that must be satisfied in order to bind a non-signatory to the arbitration agreement. So the court proceeded. So there was a shareholders agreement, which the court considered as a mother agreement, and then there were certain ancillary agreements. Also, a peculiar fact in before the Supreme Court was that not all the agreements contained arbitration clause. 3 of them did, 4 of them did not. So shareholders agreement and 2 other agreements contained the arbitration clause. Now, the court found out that all the 3 conditions are in the chloro control case are satisfied. So the court actually said that all the parties should be referred to the arbitration as per the arbitration clause under the shareholders agreement, and therefore established the jurisprudence under the Indian law for group of companies doctrine. And then thereon, there was an important point in this judgment was that the Supreme Court said there are 2 theories on which a party can be bound, a non-signatory can be bound, to an arbitration agreement. One theory is of implied consent or by transfer of contractual rights. The second theory is of agent principle or piercing of corporate veil. Now, interesting point in this, the piercing of corporate veil point is that certain high courts in India have actually said that the arbitrator does not have the power to pierce the corporate veil and add a third party to the arbitration agreement. There's no Supreme Court judgment as such on this point, but the high courts of Delhi High Court, Bombay High Court that I know of, and there might be other high courts also, they've actually held that the arbitrator cannot pierce a corporate veil. Therefore, the arbitrator does not have the power to add a third party to the arbitration agreement, which leads to a very anomalous situation in which, even though there might be instances of showing that suppose a promoter or a director of a party to the arbitration is also a promoter and director of a non-signatory, and that non-signatory was quite involved in the transaction, especially that director was probably marked on the emails that were being exchanged between the parties, then also the arbitrator does not have the power to join that non-signatory. There's no Supreme Court judgment as such saying that corporate veil cannot be pierced by the arbitrator. So that was what was held by the Supreme Court in chloro control, and that's how then there were certain more cases before the Supreme Court. And that's how the doctrine evolved. So we're going to proceed to other cases now. One of the cases then is the landmark case is Chair and Properties. Chair and Properties. In Chair and Properties, the Supreme Court was considering a different provision. It was considering Section 35 of the Arbitration Act, which talks about finality of the arbitral award, and not Section 45. Even though an argument was raised by the appellant with the Chair and Properties that the chloro controls dealt with Section 45, which was in foreign arbitration. So that's why the ratio of that judgment is not applicable to the present case, Chair and Properties, because Chair and Properties was a domestic arbitration, but the court negated that contention. And then they said it's under Section 35, and Section 35 also uses similar words as Section 45, in which it says that the party to the arbitration, as well as any person claiming under it, is bound by the arbitral award. So the Supreme Court proceeded on that basis, and they said that even though the chloro controls judgment was on a foreign arbitration, the ratio is still applicable to domestic arbitration. The principle established in that judgment are still applicable to domestic arbitration. So in Chair and Properties, there was only one agreement. So there was no the need for the Supreme Court to go into the issue of composite transaction or commonality of subject matter, because there was only one agreement and there was no situation of there being a parent agreement and subsidiary agreements or supplementary agreements. So the Supreme Court only went on the direct relationship part, and also they really emphasized on the point that of the mutual intention between the parties. Intention being the intention of the party as well as the non-signatory, the third party to the arbitration agreement, to bind themselves to the arbitration agreement. So that can be proven by, so direct relationship can be proven by the fact that the non-signatory has been involved in the negotiation, in the formation or execution of the contract, or it has been representing the party to the arbitration agreement regularly in between correspondence between the parties, um, or it has been even representing the non-signatory has even been representing the party to the arbitration in certain transactions between the parties to the arbitration agreement. So that way, the Supreme Court emphasized on the mutual intention part, and there was no analysis of the composite transaction. There was no need for that purpose. So even in Chair and Properties, the Supreme Court held that the appellant, which had challenged the enclave, it was actually an appeal from an enclave judgment. Uh, Appellant to be bound by the arbitral award, even though it was not a party to the arbitration agreement. Now, this was a very important point. Chair and Properties was not a party to the arbitral proceedings. That's why it had challenged the enforcement. So we see a different perspective when we talk about Chair and Properties. Because now, if we come to the another judgment of the Supreme Court, MTNL versus Canara Bank. So MTNL Canara Bank, as we can see in chloro controls, all the three conditions were there. In Chair and Properties, direct relationship and mutual intention of the parties. And now we come to MTNL versus Canara Bank, where the Supreme Court now devised another ground for applicability of group of companies doctrine, which was that there's a tied group structure and there is financial flow of funds between the different entities of that group. So what happened in this judgment was, first of all, MTNL challenged that there is no arbitration agreement under Section 7, which the court held, no, there is an arbitration agreement, because MTNL and Canara Bank had specifically agreed before the court that they're going to go for an arbitration. So the court said that once MTNL has agreed that they'll go for an arbitration, that's like a written arbitration agreement under Section 7, and therefore now they're stopped from not proceeding to the arbitration. Then another point was that there was a third party involved called Canfina, which was a wholly owned subsidiary of Canara Bank. Now MTNL said that, Canara Bank actually challenged that Canfina, being a third party, should not be added as a party to the arbitration agreement. The court then, as I said, applying chloro controls group of companies doctrine, and also this new ground of a tied group structure, and realizing the fact that Canara Bank was actually financially supporting Canfina, and there was a flow of funds between the two. They said that this is also an indicator that Canfina was actually intricately involved in the transaction between MTNL and Canara Bank. So therefore, the Supreme Court said that no, Canfina is bound by the arbitration agreement, and it should be referred. Referred to arbitration. And there's also a judgment. So you can see that now there's a diversion from, now there's new ground added by the Supreme Court in MTNL versus Canara Bank. Then there was also a judgment of the Supreme Court. There's another judgment in which the Supreme Court considered called Rinder's label, in which the Supreme Court considered even the correspondence exchange between the parties, and realized that in order to see that one of the promoters or one of the respondents, whether he is also he's also directly involved with the respondent number two. And by the way of him being involved with respondent number two, whether respondent number two can be added as a party. So this was a case of piercing of the corporate. Now the court in this case held that no, the respondent number two cannot be added as a party because there's no causal connection, and the promoter is not, just because the promoter is there marked on the correspondence. This is no, I mean, because group of companies doctrine is an exception to the settled principles of a company being a separate legal entity, and to privity of contract, and also to the consent of a party to arbitrate. So since it's an exception, the level, the standard of proving that a third party is a party to the arbitration agreement is quite high. So it is actually treated as an exception. That's why the proof is quite high. So we have discussed Cherian Properties judgment and MTNL judgment. Then there was another judgment called Amit Lalchand. In that judgment also, the Supreme Court basically held that even though the third party, which was a non-signatory, is not part of the same corporate structure, still it was made bound to the arbitration agreement, and the court said that it also has to be referred to the arbitration. So this was Amit Lalchand again. Even though the third party was not part of the corporate structure, now applying group of companies doctrine, they still said that the third party would be bound by the arbitration agreement. So you can see the changing, changing parameters of group of companies doctrine, which is actually the pro-arbitration outlook, the pro-arbitration approach, which is being followed by Supreme Court for the past certain years. Actually, from the shock that we had from ONGC judgment, ONGC versus Sopwith judgment, gradually from that approach, that patriarchal approach that courts had over arbitration, the SBP judgment, SBP Patel judgment, which said that even Section 11 application has to be decided in such a way that evidence can be led, and a proper procedure has to be followed. And now it has come to a point, if you see Duro Felguera, where the court said that you just have to look at the arbitration agreement. If there's an existence of an arbitration agreement, then the parties have to be referred for arbitration, and any objection that the party has can be dealt under Section 16 by the arbitrator. Then we see the judgment in Vidya Drolia, and the latest judgment in which they said that even if the agreement is not stamped, even then the parties can be referred to arbitration. It's a curable defect. So the Supreme Court has been following a pro-arbitration approach for quite few years now. So all these judgments are also in the line of that. So even though the three conditions mentioned in chloro controls are not there always present, they're not always present and satisfied in cases, but still the Supreme Court has referred third parties to the arbitration. Now, as an effect, what is happening is like the high courts now, there are certain very recent judgments like Magic Eye before the Delhi High Court, RV Solutions. Then there is Nirmala Jain judgment, Shapurji Palonji. They're all high court judgments in which high courts have taken a very lenient view. And even though there's no direct relationship between the parties, it's a composite transaction, then even then the courts have referred, or there's a commonality of subject matter, even then the courts have referred. So now, I mean, in guise of that pro-arbitration approach, now the courts have become very lenient, which now you feel that since it is an exception, so the court should probably take a more stricter approach, because at the end of the day, it is the consent of the party matters a lot. And the consent, if a party is not a party to the arbitration agreement, if it's a non-signatory, it is not given its consent, it's a separate legal entity, which is a principle, which is a norm, which is followed, and which should be looked into by the courts while discussing group of companies doctrine, and which should be given importance to. So the courts are moving away from that, which I feel now there's a need for actually giving a stricter interpretation to group of companies doctrine, saying that all of these conditions are actually satisfied, the three conditions, and it should be treated as an exception, even though a pro-arbitration approach is being taken, but still it should be treated as an exception. Now, as I said in the beginning that I was I was involved in an international commercial arbitration, we have to deal with English law also. So English law is a bit different from Indian law as regards as group of companies doctrine. So under English law, there's a quite famous case called Peterson Farms versus CNM Farming. So in that case, the arbitral tribunal had actually applied group of companies doctrine and held that the parties are not, the third party is not bound by the arbitration agreement. The matter reached the court. Um, the High Court basically held that the arbitral tribunal should not have applied group of companies doctrine directly. The settled law is that an law governing arbitration agreement is usually the law governing the contract in international arbitration. So the court held that the tribunal could not have applied group of companies doctrine directly. They should have considered what is the law governing the contract, or at least law governing the seat. The law governing the contract was Arkansas law, and the law governing the seat was English law. So they said that the arbitral tribunal should have decided as per Arkansas law, and then if that law allowed group of companies doctrine, then they should have applied it, not directly. So that ways English law diverges from Indian law, because in chloro controls also it was a foreign arbitration. It was governed by English law. The seat was in London, and ICC rules were applicable. But the court directly applied the group of companies doctrine and didn't go into the issue of determining what is the law of the arbitration agreement, which is the law governing the contract, which is law governing the seat, and they directly went to us. That is the one major difference between English law and Indian law. So as I've said, that the group of companies doctrine is actually being used by Supreme Court to propagate that pro-arbitration approach. But considering that it is an exception, a high standard of proof should be required to apply this doctrine. So, Jay, basically, this is my small, presentation on group of companies doctrine, and I hope it was informative. And if you have any questions, then please feel forward, to ask those.
Thank you so much there, Mr. Abhishek Shivpuri, for your valuable insights on this really novel concept. Not much jurisprudence that we have on this. So basically, to sum it all up, I think it is an exception to the rule of privity of contracts. That is the arbitration which takes place, the arbitration agreement between the parties. And we can also say that it is an exception to Section 7 of the Arbitration Conciliation Act, that it must be in writing and thereby being enforceable only against parties who are signatories to that arbitration agreement. So but I think it is also very important to understand that certain circumstances need to be referred or demonstrated so as to fulfill the requirements of applicability of this doctrine.
Exactly. So
these compelling circumstances have to be mentioned, right?
Yes, compelling. That's what I said, that it is an exception. And so the standard of proof is high. So if you want to show direct relationship between a party, suppose, then you have to show that there was actually the third party was intricately involved in the formation or execution of the contract, that third party was sometimes even represented that party to the arbitration agreement. So, this standard of proof is high, but right now, like if you I forgot to talk about the Amazon versus Future Retail Limited judgment also. The recent judgment, and of course, it was in limelight. So yes, so what happened? A very interesting question was raised in that judgment, which was that an arbitral tribunal does not have the power to basically apply a group of companies doctrine and add a third party. They said it can only be done under Section 8, which is when parties are before a judicial authority, and the judicial authority only can decide, apply group of companies doctrine and add a third party to the arbitration agreement, right? So the court negated that contention and said that, the arbitrator, so the arbitrator was the emergency arbitrator in that case, which the SIAC had appointed. And he had actually considered the whole jurisprudence on group of companies doctrine, and then held that FRL, which is Future Retail Limited, is part of the Biani group of companies, and it satisfies all the tests of chloro control, and it should be added as a third party. And the Delhi High Court also then reproduced the entire jurisprudence and then considered that the award of the emergency arbitrator was a correct one. So that was also a major step towards, applicability of group of companies doctrine in that regard.
So true. I think this judgment is perhaps laying down the foundation of the application of doctrine. And I think many high courts have also taken, for example, Delhi High Court, as you rightly pointed out, did discuss it in great detail. But we are yet to see its concrete application so far as this doctrine is concerned. In the interpretation that is causing difficulty in minds of so many people. So thank you so much there, Mr. Shivpuri, taking out time for this lovely session on this very doctrine, which is a very novel concept in the field of arbitration law. So thank you so much. A big thank you to all
My
the
pleasure.
people. Thank you so much.
Thank you for inviting me.
Definitely my pleasure. And stay tuned. Next episode is on its way. So it's goodbye for now. Thank you.
Thank you.